A man walks into court charged with driving on a suspended license, and instead of saying, "Yes, Your Honor," he starts throwing out words like beneficiary of trust, TIN numbers, and maritime law. No lawyer, no legal training, just confidence, and a whole lot of terminology he picked up somewhere on the internet. The judge, ice-cold patient, but watch closely, because every answer this man gives is about to dig him deeper. This is what happens when you show up to court thinking you know more than everyone in the room.
26.
Good morning, Mr. Williams.
Good morning, Your Honor.
Do you have a lawyer today?
I don't, I object to the request.
You object to the request.
Yes.
Shh.
The defendant is a beneficiary of the trust.
The defendant is a beneficiary of the trust.
Yes.
You are the defendant.
The defendant is recognized by the social. I do not have a social. I have the TIN,
And what is a TIN?
the tax identification number.
I thought it was an EIN.
It's,
that's
Employee identification number. Isn't it an EIN? Okay.
Yes, so I, Jamona Williams, is the representative of the defendant that is the beneficiary of the trust. So I am here to offset whichever debt and understand the nature of these charges or the criminal, admiralty, maritime, or whichever jurisdiction before I can proceed.
Okay. Well, I just wanted to know whether you have a lawyer today and if you've talked to anyone. That's it.
Also have a lawyer.
Okay.
And I would like for the court to be in motion to dismiss these charges.
Okay. I mean, you're welcome to file them. We're not going to do it for you. You're welcome to file any documents that you want. You can do
I
that.
have tried to before with your county clerks and they keep on denying my documents.
Go to the third floor, go to the third floor, the customer service, and I think that they can take anything that you want to file.
They send me to the third floor, to the ninth floor, every time. The confusion and it's a violation, federal violation of the county law.
Have you guys seen anything that he's filed?
No, personally, I haven't.
Not her, it was another lady that was here before.
Okay, you're welcome to file anything and we'll take it for you if you'd like. But, I mean, you have several ways that we can go forward. You can represent yourself. You can hire a lawyer. You can apply for a court-appointed lawyer if you'd like. How would you like to go forward?
I would like to represent myself.
Okay. Sure. Let's do this. I have some business to handle. We need to do what's called a Beretta hearing, because I need to have put a hearing on the record to see whether you should represent yourself. Just because you can doesn't mean you should. If you need open heart surgery, are you going to, operate yourself? I mean, you probably could, but it's probably not a good idea. It's the same thing with the legal case. You may not know the rules of evidence. You may not know the rules of criminal procedure. You may not know the Texas Penal Code. If you try to admit something and you don't do it the proper way, it'll get denied, because when you represent yourself, we treat you as if you were a lawyer, you yourself. So let me have you take a seat in the jury box. Let me handle all the business, and then Ramona's here, right?
Yes, Judge.
We'll have a hearing on the record, and then you're more than likely to represent yourself. Just remember, you have the right to remain silent. Anything you say can or will be used against you. So if you end up representing yourself and you talk to the DAs and you say something where you think it's helping, but in reality it hurts you, they may very well use it against you to prove guilt. Okay? So just hang tight. Give me 10 minutes. Let me get through stuff, and then I'll call you up and then we'll do the hearing. Okay, sure. Ramona,
You're gonna take this form off of the first letter of collection so they can leave it.
Yes, Judge.
are you ready?
Yeah, let me come out there. Yes,
You want to come out here?
yes.
Okay.
Just share, just share.
Ramona, tell me when you're ready.
I'm ready to go.
You ready? Okay. Everyone, we are about to go on the record. If you need to talk, please go outside. Do not talk while we're on the record. What was the last name again? Hey. What's the last thing that I think?
Oh. Page 20. 26.
That's right. Mr. Williams, coming up, sir. All right. We are on the record in cause number 260-6568, State of Texas versus Andrew Williams. Mr. Williams has been charged with driving while his license is suspended. He's facing up to 6 months in jail and/or a $2,000 fine. Today's date is April 27th, 2026. It's approximately 10:26 in the morning. Guys, if you please will announce yourselves for purposes of the record with the state going first.
Corwin for the state of Texas.
And you are,
Andrew Morgan Williams for the defendant, Andrew Morgan Williams.
okay. Mr. Williams has indicated to me today that he would like to represent himself. So I'm going to just go through a series of questions so that everyone here is protected in the event that he wants to go forward representing himself so that he understands fully what the consequences are so that he can't come back at a later time and try to make a complaint or this or there. You need to fully understand what you're facing. So I'm going to ask you a series of questions. If you don't mind just letting me know. So how old are you? Mr.
44.
Where were you born?
St. Thomas, West Virgin Islands.
Do you read and understand English?
Yes,
Do you have any learning disabilities or communication handicaps?
no,
Have you ever been declared mentally incompetent or treated for any mental health disorder?
no.
What is your educational background?
Some college,
Did you graduate from college?
no,
Do you have any legal training, education, or experience?
I'm a certified combination welder. I'm a certified medical assistant.
Sure. But do you have any legal training or experience?
None,
Have you ever represented yourself in a prior legal proceeding?
no,
Do you understand the charges against you?
no. I don't speak Japanese.
You don't speak legalese. You were charged with driving while your license is suspended or invalid.
There's no evidence.
Hold on. I just need to understand whether you know what the charges are and whether you understand it. We're not going to dispute the case now.
I recognize.
So you do understand what the case is.
Yes,
Do you know what type of punishment you are facing?
no,
You are facing up to 6 months in jail and/or a $2,000 fine.
okay,
Do you understand that now?
I understand.
Okay. Do you understand what the range of punishment is if you are convicted of these charges?
Yes,
You have the right to court-appointed counsel. Do you want to waive that right?
yes,
Is your waiver done intelligently, knowingly, and voluntarily?
Yes.
No one has forced you to do any of this.
No,
Do you understand that you will not be able to claim ineffective assistance of counsel at a later time if you are unsuccessful at trial?
understood.
Do you understand that if you elect to proceed pro se, meaning that you represent yourself, you must comply with the same technical rules of evidence and appellate procedure as a lawyer?
Understood.
Do you understand that you will not be granted any special consideration because of your lack of formal legal training?
Understood.
You understand that because of your lack of formal legal training, you may fail to raise points of error that may exist in the trial record.
Understood.
Are you familiar with the Texas Penal Code?
A little bit.
Are you familiar with the Texas Code of Criminal Procedure?
I've read a little bit.
Are you aware of the dangers and disadvantages of the dangers of self-representation?
Yes,
Knowing that you're untrained, without prior legal experience, and not familiar with the rules of evidence or procedure, do you want to waive your right to effective assistance of counsel?
I'd like to waive I don't waive any of my rights, right, for the record, right?
For legal counsel,
I do not waive any of my Bill of Rights, amendment rights, constitutional rights.
I understand that. Yes, but this is just for purposes of a lawyer.
Please, for the record.
Understand that if you do decide to represent yourself, you must comport yourself in an orderly way. You cannot use this to obstruct justice, to make a mockery or whatnot. You'll be held to the same standards. You understand and okay with this? Okay. I am happy with you to represent yourself. We just need you to sign a document stating that you're going to formally waive. And then at that point, we will have you speak to the district attorney and you guys can work out whatever you can want. If not, at that point, we can set the case for trial and we'll just go from there. Do you have any questions?
No questions.
Okay. All right. Off the record. Okay. So what'll happen now is I'm going to reset your case. The case isn't old, right? It's what, 30, 40 days?
February 17th.
Do you have the waiver
Yes, sir.
printed so we can have him sign it? So what I'm going to do is we'll reset your case to around 30 days. We'll need you to come back every setting so that because you're representing yourself, you'll have to be here. You'll need to get together with the district attorney's office to go through all the evidence that they have to prosecute this case against you. They're not going to give you copies, but you can take notes and prepare, bring a lot of paper so that you can take notes and you can write down everything that they have. You obviously have access to all the public documents, so you can go to the third floor and they'll give you copies of anything that you may need that's in your case file, this public record. If you want to file anything, come to me and I'll accept anything that you want to file, and then we can just make it a part of the file. Don't go to the third floor, just come here and then I'll take it for you and then we can file it here.
So can I give you my documents now?
Sure, absolutely. Yeah. So understand that you'll need copies for them as well. So anything that you file here with the court, you will also have to give a copy to the DA. So if you don't have copies now for everybody, we can set it a week, 2 weeks, you pick. You're the master of this case. So I'm happy to do whatever date you want, but whatever you're going to serve here, you also need to give them copies as well. Okay?
All right, can I have an address for the office that I can meet with them or?
Yes,
Yes, I can get an address. It's,
it's in this building, right? It's, yeah, fifth floor or where?
It's the fifth floor of this building.
Yeah, this building, go to the fifth floor. Do you have a card?
Yes, I do.
Why don't you give him a card? It might be easier that way. She's going to give you a business card so that you have it. That way, if you want to mail anything, it might be easier for you just to bring it here and then we can file it and then we can also give her a copy. So that way we can all make notations that you've done what you've done. So there's proof. And then we'll just give you time. You want to try to set up a meeting now so that you have something? What do you have? What discovery do you have?
911
Okay,
and body cam video. Body
Okay.
cam and dash cam.
got it. So did you hear that? They've got a 911 tape. They also have body camera footage. So when you come to their office, you can sit down. They will have an investigator that sits with you and you can watch, listen to everything and take notes. And then after that, go and then we come back and then go from there. Okay? Okay. Good luck. Yes, sir.
The judge gave this man every opportunity, explained the charges, outlined the risks, offered him counsel, and still let him choose his own path. No one forced this outcome. He walked in using borrowed legal language, waived his right to professional help, and now faces body cam evidence alone. The question is simple. Was this confidence or was this pride dressed up as strategy? Do you think the judge was right, or did this defendant waste his only real chance? Comment below, hit like, and subscribe for more real courtroom breakdowns.